like the blame should fall on the bystanders for displaying concern over a man's life? What? But this was a distraction, and there was some concern. The defendant doesn't appear too concerned. It wasn't the bystander's fault. A 19-year police veteran, a field training officer, with over 800 hours of training, should not be distracted by the comments of a 17-year-old or being filmed by some civilians. There's a policy about filming. They understand that civilians can film them. They know that. It's right there. This isn't something new or earth-shattering or even particularly noteworthy. Sergeant Steiger, you recall him from LAPD. He used to patrol on Skid Row. He talked about people throwing rocks and bottles. They have a phone. They have phones. They're expressing concern. They're not doing anything. This is not a justification for an assault, for murder. Defense suggested in their cross-examination that reasonable minds can disagree, or that some of the witnesses don't line up exactly where the force began or what exactly should be done, but don't get caught up in that. Don't miss the forest for the trees. Right? Consider the testimony as a whole. Officer after officer after officer got on that stand, raised their hand, and told you, the chief of police, right, that this conduct, the 929, violates the use of force policy, violates the department's core values. He violated his duty of care. He failed to render aid. Remember Commander, now Inspector Katie Blackwell, who was in charge of all training, looked at this and said, I don't even know what this is. I don't know what this modification is. This isn't how they train. These aren't the rules. Lieutenant Mercel looked at this and he said, without equivocation, not an MPD trained tactic. It is not. We don't train our people to do this. You can present 1,000 hypothetical situations. You can talk about what didn't happen all day long into next week. But when you talk about what did happen on that day, at that time, that's what they said. Use of force, unreasonable. Supervisor, Sergeant Pluger, the force should have ended right after Mr. Floyd was on the ground. His supervisor said that. Lieutenant Zimmerman, the oldest serving, or I should say the most years of service on the Minneapolis Police Department, longest serving, correct myself, longest serving member of the department. What did he say? He looked at this. He said this was totally unnecessary. Totally unnecessary. A use of deadly force. Not reasonable. Only reasonable force is authorized. Sergeant Steiger, expert witness, Los Angeles Police Department. He's trained thousands of police officers. He looked at this. This is objectively unreasonable force. Professor Stoughton, former police officer, University of South Carolina Law School professor. This use of force was unreasonable, it was disproportionate, and it violates national standards. The experts agree. Because the force has to be reasonable when it starts, it has to be reasonable when it ends. And what is happening? If you look at the bottom, George Floyd is handcuffed and on the ground. Right? What is he saying? He's saying, I can't breathe 27 times within the first 4 minutes and 45 seconds of this encounter. He's saying that. And the defendant continues to kneel on his back and neck, continue the dangerous restraint. George Floyd says, into the restraint at 8:22:24, my stomach hurts, my neck hurts, everything hurts. Defendant heard that. He heard those words. Was George Floyd resisting when he was trying to breathe? No. No. And the defendant heard it, and he acknowledged it, and all he did was mock him. It takes a lot of oxygen to complain. That's what he said. It takes a lot of oxygen to say that. When George Floyd gave his final words to the defendant, "Please, I can't breathe. I can't breathe," crying out for help by the man in uniform, the defendant stayed right on top of him, ignored it, continued doing what he was doing, facing the crowd, grinding his knee, twisting his hand. "I think he's passing out," Officer Lane says. Officer King can't find a pulse. Now, the greatest skeptic of this case among you, how can you justify the continued force on this man when he has no pulse? No pulse. Continued. The restraint continued grinding and twisting and pushing him down and crushing the very life out of him. It wasn't too late. He could have rolled him over, performed CPR. No, he continued. Past the point of finding a pulse, past the point where the ambulance arrives, past the point where the EMTs get out of the ambulance. What's the goal? What's the plan here? What are we trying to accomplish? This was a counterfeit $20 bill, allegedly. Right? What is going on? Why hold him that long, past that point, past that line that was crossed? Oh, unreasonable force. Unreasonable. Not proportional. Excessive. It violated policy. It violated the law. It violated everything that the Minneapolis Police Department stood for. It is not lawful. I use that phrase, awful but lawful. Right? But force that is not lawful, it's just awful. So the defendant is guilty of second-degree murder. He's guilty of third-degree murder. He's guilty of second-degree manslaughter. All of them. Because this was not a justified use of force. You cannot justify this use of force. It's impossible. Not if you apply the rules, not if you apply the standards. That a sworn officer to protect and serve, but a sworn officer, that oath that they take. You know, at the beginning of my comments, I talked about George Floyd's life, how he was surrounded by people who cared about him, surrounded by familiar faces, people he could look out to in the crowd. But at his death, he was surrounded by strangers. They were strangers, but you can't say they didn't care. You can't say that. These people were randomly chosen from the community, people from the community randomly chosen by fate. And they were coming from different places, and they were going to different places, and they had different purposes, all of them. Random members of the community, all converged by fate at one single moment in time to witness something, to witness 9 minutes and 29 seconds of shocking abuse of authority, to watch a man die. And there was nothing they could do about it because they were powerless. They were utterly powerless because even they respected the badge. Even seeing this happening, they cried out at first, pointed out, hey, you can get up off him. It became more and more desperate as they watched us go on and on and on, and there was nothing they could do. All they could do was watch and gather what they could. Gather their memories. Gather their thoughts and impressions. Gather those precious recordings. And they gathered those up and they brought them here And they brought them here, and they got up on a stand, and they testified, and they bore witness to what they saw. They bore witness to this outrageous act, and they told you about it, and they gave you what they had, their thoughts, their impressions, their memories. They gave you those precious recordings so you can see this. You can see this from every single angle. They gave that to you. They were powerless to do anything but that. They gave it to you. Randomly selected people from the community. You got a summons in the mail. And here you are. All converged on one spot. Now, our system, we have power. The power actually belongs to us, the people. And we give it to the government in trust for us to hold and to use appropriately. But sometimes we take it back. Sometimes when something is really important, we reserve those decisions for ourselves. The state, we have power. We cannot convict the defendant. The judge has power, but he cannot convict the defendant. That power belongs to you. You have that power, and only you have the power to convict the defendant of these crimes, and in so doing, declare that this use of force was unreasonable. It was excessive. It was grossly disproportionate. It is not an excuse for the shocking abuse that you saw with your own eyes. And you can believe your own eyes. This case is exactly what you thought when you saw it first, when you saw that video. It is exactly that. You can believe your eyes. It's exactly what you believed. It's exactly what you saw with your eyes. It's exactly what you knew. It's what you felt in your gut. It's what you now know in your heart. This wasn't policing. This was murder. The defendant is guilty of all 3 counts. All of them. And there's no excuse. Thank you.
Members of the jury, we're going to take a 20-minute break, and just for your information, we'll also take a 20-minute break after the defense argument, before the state's rebuttal and the final instructions.
All right, welcome to For the Record. I am Bob Bianchi. I'll be taking it to 3 o'clock. Amazing with regard to the closing statements. The prosecutor went first. Let me go right to our guests, Roger Foley and Lara Uretzian, our criminal defense attorneys. I'm sorry, I just have Roger on for right now. Roger, how did you think the prosecution did?
Well, I thought it was a little slow, Bob. It had its moments, but for the great length of it, I thought it was overdone. Our job is to critique. It wasn't a storytelling. It was blah. It was monotone. And I wouldn't be surprised if some of the jurors were starting to sleep at this point at the trial.
Yeah, Roger, I've been trying to say this from the beginning of this case, that it cannot be properly analyzed unless you understand what the law is. And we've desperately tried to get the jury instructions and what the law could be. The judge read it in the beginning of the case because a lot of people claim cop cases are hard to prosecute. I can tell you as a homicide prosecutor that's been involved in police cases where they're defendants, it's because of that justification defense that they're given that other ordinary citizens aren't. That is whether or not they're using reasonable force with regard to apprehending a person or trying to prevent an escape. And so it always comes down to that word reasonableness. As far as the jury instructions were concerned, they were pretty clear to me. Were they to you as well? And doesn't it make it more complex for winning cases against police officers the way it's written?
It does, but I do think that they were clear, and I do think that the judge did his job. He explained the law to the jury. He started off in the beginning we've had moments. The prosecution talked about it a little bit too during their closing, what the elements were, and they broke them down nicely. So I don't think that that's going to be the question for the jury. I mean, the country's split on this question, Bob. It comes down to, do we have a bad cop that caused the death of George Floyd, or was the death of George Floyd due to using of drugs? That's what it comes down to. So the credibility of who the jury believes in regards to the experts, because the experts are split. One expert says this, one expert says this. So which expert do you believe?
Well, you know what, Roger? We are going to get into the civil complaint that was filed in this case that did a better job detailing the police department's procedures that caused this, as opposed to Chauvin's actions, which they say were the result of the training. But we're going to have to get to that on the other end of the break. Stay with us. Okay, we're done with the prosecutor's closing statement, waiting for the defense closing statement. In the meantime, we have our boots on the ground, Kim Johnson, out there on this monumental day with this monumental case. Kim, what's going on?
Hi, Bob. Yeah, great to be with you. It is hard to believe that here we are, the day of closing arguments. And this morning, 14 men and women packed their bags and kissed their loved ones goodbye, not knowing when they will see or be able to talk to them again, only knowing that it is now going to be up to them to decide on a verdict and agree on a verdict for Derek Chauvin. Now, the trial of the former Minneapolis police officer resumed just after 9 a.m. Central Time. That is when Judge Peter Cahill, who's residing over this trial, gave instructions to the jurors. And that is when prosecutor Steve Slisher began presenting his closing arguments to the jurors. He started by saying the name of George Floyd, saying the day that he was born, where he was born, naming his parents, and then going into detail about his love that he had for his mother. So sort of bringing this alleged victim to life again in the courtroom. But he didn't waste time. He quickly went in to describe the events, the elements of May 25th, 2020, the day that George Floyd died. He said all that was needed that day was a little bit of compassion, and none was shown. We do have a clip of what he told the jury. Let's play that right now.
Desperately crying out. A grown man crying out for his mother. A human being. And in that time and in that place, while he was surrounded in life by people he knew him, faces he could pick out, there was no one there he knew. He was surrounded by strangers. Strangers, all of them. 9 minutes and 29 seconds. He's surrounded by strangers, not a familiar face to say his final words. But he did say them to someone. He said them to someone who he did not know by name, but he knew him from the uniform he wore and the badge he wore. And he called him Mr. Officer. That's what he called him, Mr. Officer. Mr. Officer would help. We call the police when we need help. And he pleaded with Mr. Officer. George Floyd's final words on May 25, 2020 were, "Please, I can't breathe." And he said those words to Mr. Officer. He said those words to the defendant. He asked for help with his very last breath. But Mr. Officer did not help. The defendant did not help. He stayed on top of him, continued to push him down, to grind his knees, to twist his hand, to twist his fingers into the handcuffs that bound him, looking at him, staring down at times the horrified bystanders who had gathered and watched this unfold. The motto of the Minneapolis Police Department is to protect with courage and to serve with compassion.
And now Slisher told the jury that this is not the state of Minnesota versus police. It is the state of Minnesota versus Derek Chauvin, saying policing is a noble profession. This is not about police, but the reckless actions of Chauvin. Slisher also tried to get out ahead of what will likely be the defense's main points in its closing argument, that Floyd died of an overdose combined with heart issues. Slisher asked the jury, did he miraculously just die of the drugs, his heart, and the tailpipe? You can trust your eyes. Use your common sense. He said that is something he reiterated over and over. You can trust what you saw when you first saw the video. You can trust your eyes. You can trust your gut reaction that is actually what happened, because we know many of the jurors, they did say in questioning that they had already formed an opinion, but that they could put it aside. Well, now Steve Slisher, the prosecutor, is asking them to go back to that opinion that they already had formed. Now, when defense attorney Eric Nelson is done presenting his closing statements, then the state gets a rebuttal that will be made by prosecutor Jerry Blackwell. Then, before the jury is sequestered for deliberations, Judge Cahill will excuse 2 of the 14 jurors who heard this case. Which 2, we don't know. That has not been made public yet. That is up to the judge. So while the public isn't sure which 2 of the 14 jurors will not be having a say in the verdict, those 2 jurors, they also don't know. They haven't known. They've been taking notes as if they will be the ones going into deliberations and will be deciding on a verdict. So that should be pretty interesting once we learn that information. Bob?
All right, Kim Johnson doing a great job out there. Thank you very much. And of course, as Kim was just indicating, talking about how it's not against the police. That's the prosecutor going for those 1 or 2 or potentially 3 jurors that are police supporters. Kim also mentioned the issue about the tailpipe and the carbon monoxide poisoning. Kim, I want to thank you because I want to get to that clip real quick about a motion that was filed last week about a report that the state gave at the last minute and after the defense doctor testified that carbon monoxide could be in play, showing actual carbon monoxide figures the defense never had prior to the expert testifying. Let's take a listen.
This argument was all about carbon monoxide and whether or not there was enough of it in George Floyd's blood to contribute to his death.
If he even hints that there are test results that the jury has not heard about, it's going to be a mistrial.
A stern warning from Judge Cahill to prosecutors after they announced they plan to call breathing expert Dr. Martin Tobin back to the stand to rebut claims from a defense expert that said carbon monoxide from a police cruiser exhaust system could have killed George Floyd.
Dr. Fowler was pretty clear. He was not saying that this was the cause of death. He's simply opining that it wasn't considered by the state. And apparently it was considered to be a ridiculous concept by the state of Minnesota that they didn't think to test it.
Dr. David Fowler told jurors Floyd's carbon monoxide levels should have been tested. Now, prosecutors say they have those test results.
It was discovered yesterday by Dr. Baker.
Special prosecutor Jerry Blackwell said Baker reached out to them after hearing Fowler's testimony. Judge Cahill called the late disclosure prejudicial to the defense.
It's just by serendipity that Dr. Baker calls the state and says, oh, by the way, it does exist. It should be in there. It seems to me very odd. I'm not claiming any bad faith on the state's part.
Cahill allowed Dr. Tobin to return to the stand to testify about test results the jury had actually seen.
If the hemoglobin is saturated at 98%, it tells you all there was for everything else is 2%. And so the maximum amount of carbon monoxide would be 2%.
Tobin says 2% would be in the normal range.
Dr. Tobin testified that the knee on George Floyd's neck actually cut off his airway, which led to oxygen not being able to get to his brain, while Dr. Fowler testified that the knee on George Floyd's neck did not cause his death. For the Law and Crime Network, I'm Anjanette Levy.
That's a great report by Anjanette Levy from the Law and Crime Network. Roger, I want to go to you with this. This really shocked me. I'm confused by this case in so many ways. As a former prosecutor that prosecuted many homicides, as a criminal defense attorney that's handled a number of homicides, this is an outrageous discovery violation. And I would have been asking for a testimonial hearing. If I were the defense attorney, I want to know why it was not released, and moreover, what else may not have been released. And my second point I want to bring out to you, this is really important because I think this could come back on appeal, but the lawyer never developed the argument. The prosecutor in summation is attacking the defense doctor, saying he came up with this carbon monoxide thing, which he would not have done had he been given the report in the first place. I cannot believe the judge did not give a curative instruction to the jury saying evidence was withheld and really spanked the prosecutor for this in front of the jury. But no, the jury is now being allowed to assess the credibility of the defense doctor, saying he came up with this cockamamie theory when he never had the report. What do you think, Roger?
Bob, first of all, I know that as a prosecutor, you wouldn't have made that mistake. And I think that the defense would have been in a lot more trouble had you been the prosecutor. As I was watching this trial, I was thinking, is this the best prosecution team that Minnesota can put together? Because there's problems. This discovery violation is huge. I mean, you just don't see the imagination runs wild with how did they miss this? How did it not get turned over to the defense? And then, as you're saying, in closing, to be able to point out, like, oh, how did the defense experts even come up with this? Unbelievable, but I understand why the judge didn't do it, Bob.
Yeah, but Roger, listen, the credibility of the expert witness is key. And the prosecution now is skewering that expert, who is a very credentialed person, based upon something where the state did not give him the information. That is, to me, an outrage. It should not have been allowed to occur. Do you see an appellate issue there?
Absolutely. I agree with you 100%. If Chauvin is convicted, it is one of many issues that would come up on appeal.
Yeah, and listen, I don't. Are you confident where cause of death is a very important thing in this case? How was Nelson, Mr. Nelson, the defense attorney, confident that something else wasn't withheld from his? I'd be asking for a mistrial. I'm shocked it went away in the night, and he's allowing his expert to be skewered now in closing statements and not even stopping it, going to the judge and saying, this is outrageous that this is being done, Judge. I want you to instruct the jury about what happened here, because that would really hurt the prosecution.
Well, 100%. Anytime you don't receive discovery information, it's a violation of the Brady rule. And for jurors, defense teams are entitled to all the information, everything that encompasses the prosecution of the defendant. So there's no surprises. It's not a trial by ambush. It's so that the defense can go systematically, piece by piece, analyze each piece and have whatever rebuttal they may have a defense, have a theme. But without that information, it severely prejudices the defense. And as you say, it's a huge issue made for appeal.
I've seen a lot of due process arguments that are going to be coming on appeal, but I am still struck so many times the defense has not raised issues and developed them enough on the record for that appellate issue in my mind. All right, I'm going to calm down. We're going to take a break. We'll be right back. Okay, in case you're just joining us, the prosecutor is done with their initial part of their closing statement. They're on a 20-minute break. We're really close to that 20-minute period right time. I've got Roger Foley with me. Roger, I want to get into one area that I was really surprised at as it relates to use of force, and that is this civil. Never mind. We're going to court. We're not taking any breaks or any interruptions. You're going to hear it all. Stay with us. Back in the court.
May it please the court, counsel, Mr. Chauvin, members of the jury. I want to take this opportunity first to thank each and every one of you for your service, your diligence, and your attention to this matter. We all recognize the disruption that jury service places on your personal and professional lives, especially in a case of this magnitude and duration. And so on behalf of Mr. Chauvin, I want to thank each and every one of you for your attention and service to this jury. I'm going to apologize if I get a little long-winded, because I get one bite at the apple here. The state has an opportunity to rebut my statement after this. There's so very much we need to cover. There's so very much we need to talk about, and it is all important. Before I begin my review of the evidence in this case, I would like to address two very crucial points of law, and they were touched on by the state. The presumption of innocence and what proof beyond a reasonable doubt means. The presumption of innocence, the defendant is presumed innocent. That's the starting point. He's presumed innocent of these charges, and this presumption remains with him throughout the course of the trial, the presentation of the evidence, throughout the course of your deliberations, until and unless the state has proved its case beyond a reasonable doubt. The defendant does not have to prove his innocence. We talked about this in jury selection. We talked about the starting point. The defendant doesn't have to try to catch up. He starts at the presumption of innocence. Proof beyond a reasonable doubt. Here's the definition that the judge just read you. Proof beyond a reasonable doubt is such proof as ordinary prudent men and women would act upon in their most important affairs. A reasonable doubt is a doubt that is based upon reason and common sense. It does not mean a fanciful or capricious doubt, nor does it mean beyond all possibility of doubt. The law recognizes three standards of proof. The preponderance of the evidence is the first and lowest standard. Clear and convincing evidence is the next standard. And the third standard is proof beyond a reasonable doubt. And the way we lawyers sometimes illustrate what these three standards mean is through the scales of justice, right? The scales of justice equally balanced. When you apply the standard of the preponderance of the evidence, it's also called the scintilla of the evidence. A single grain of sand tips the scales in the favor of one party or the other. And this burden of proof is used in many civil cases. If the state wants to take away your driver's license, for an example, that is the burden of proof that the state has in that type of a case. They have to just ever so slightly convince the finder of fact that their evidence supports their action. The next standard is clear and convincing evidence. I mean, that's pretty self-explanatory, right? It is clear evidence, and it convinces you, the finder of fact, that the action is correct. This is the standard of proof that is used if the state wants to take away your children. Clear and convincing evidence. It tips the scales more in the favor of one party over the other. The highest standard in this country is proof beyond a reasonable doubt. Proof beyond a reasonable doubt. Essentially, what the state has to convince you is that the evidence in this case completely eliminates any reasonable doubt, or in other words, leaving only unreasonable doubt. Capricious, fanciful. Capricious doubt, capricious means unpredictable. Fanciful, space aliens flew in, inhabited the body of Derek Chauvin, and caused this death. That's fanciful. Beyond the reasonable doubt. It is the highest standard in the law. Doesn't mean beyond all possibility of doubt, because I suppose space aliens may have been inhabiting his body, but that's obviously fanciful and capricious. So these two standards, the presumption of innocence and proof beyond a reasonable doubt, work in concert with each other. You start with the proposition that Mr. Chauvin is innocent of these charges. the state has to advance substantial evidence to convince you that the only doubts that are remaining are unreasonable doubts. As you analyze the evidence in this case, you would simply have to find that any defense that has been advanced is unreasonable. That's what this standard is all about. I want to take this opportunity also to talk to you about the importance of reading the entire instruction. Because I've seen, and lawyers, and I'm going to do it too, right? We pick and choose those things that help us make our case and help us argue our case. That's our job as lawyers, is to point out words and phrases within the instructions that make the difference in the case, and to take that evidence and present it to you in such a way that it supports our proposition. That's what we do. That's why you are instructed that if your memories of the evidence is different, that if the judge's law is what applies. But take the time to carefully read the entire instructions. Throughout the course of this trial, you've seen us do this, right? Little snippets. A second here, a second there, a screenshot here, a screenshot there. You need to review the entirety of the evidence in this case during the course of your deliberations as well. And I can tell you that some of the videos that we've seen, they're much longer than what was presented in court. There's additional information, and you're going to see some of that as we go through this case today. So take the time and conduct an honest assessment of the facts of this case, compare it to the law as the judge instructs you, and the entirety of the law. That's why the instructions tell you, consider the instructions as a whole. I've told you that lawyers like to present evidence that favors them, right? But we have to be intellectually honest about the evidence. We have to present it in an honest and intellectually cohesive and coherent manner. And I have to address something that I think is important. And I think it is a prime example of what I am asking you and what is your obligation to do, to look at the evidence in light of all of the other pieces of evidence, right? So you heard during the testimony of Dr. Fowler that one of the things that he considered is the possibility that carbon monoxide was present and could have contributed to an environment that created an oxygen deprivation. You heard that testimony. In rebuttal to that testimony, the state brought Dr. Chauvin back in, and he told you, we can completely disregard that. We know as a fact, we know conclusively that Mr. Floyd did not have carbon monoxide because his oxygen was saturated to 98%. And you just heard the state say, just like I am right here, right? So it stands to reason. I could get up in front of you and I could argue to you, we know this wasn't asphyxiation because George Floyd had a 98% oxygen level. How could he have been asphyxiated at the hospital with a 98% oxygen level? But that's not intellectually honest. It doesn't stack up against the rest of the evidence because of what we know, right? We heard the testimony of Seth Bravender and Derek Smith, the paramedics. We heard the testimony of Dr. Langenfeld. They came in and they said they began resuscitative efforts. They introduced oxygen, an oxygen supply. They're manually breathing for him. They're reoxygenating his blood. So when you look at that piece of evidence, when you look at a piece of evidence like that, you have to compare it against all of the other evidence. Because you can't come in and say, George Floyd, on one hand, George Floyd died of asphyxiation, but he has a 98% oxygen level, right? His blood is oxygenated. Then stands to reason the opposite is true as well. You can't come in and say, I can conclusively prove that Mr. Floyd didn't have carbon monoxide in his blood because he had this high oxygen saturation. You test one statement against the evidence of other people and you compare it. That is what you as jurors are obligated to do and what I am asking you to do. Compare the evidence against itself. Test it. Challenge it. Compare it to the law. Read the instructions in their entirety. Start from the point of the presumption of innocence and see how far the state can get. I submit to you that the state has failed to meet its burden of proof beyond a reasonable doubt. Mr. Chauvin has been charged, as the state indicated, with these 3 charges, and the judge has instructed you. Count 1 is second-degree murder while committing a felony. It's also called the felony murder rule in Minnesota. Kind of the textbook example is I run into a liquor store, I pull a gun, I'm intending to rob the liquor store. My gun goes off, I shoot and kill the teller. I didn't intend to go in and murder that person, but the death of that teller occurred while I was committing a felony. That's the felony murder rule. He's been charged with murder in the 3rd degree for performing an intentional act that is eminently dangerous. Right? You've seen the instructions, you've heard them. And manslaughter in the 2nd degree. Again, the law has all of the words, it defines the words you need, and the instructions should be considered in their entirety. Whenever I meet with a client, I try to explain what the elements are, and this is the analogy that I use. I say that a criminal case is kind of like baking chocolate chip cookies. You have to have the necessary ingredients. You've got to have flour and sugar and butter and chocolate chips and whatever else goes into those chocolate chip cookies. If you have all of the ingredients, you can make chocolate chip cookies. But if you're missing any one single ingredient, you can't make chocolate chip cookies. It's a simple kind of analogy. But the criminal law works the same way. We say, we call the ingredients the elements. The state has the burden of proving each and every element beyond a reasonable doubt. Not just some global proposition that they've proved their case beyond a reasonable doubt. They have to prove each of these elements beyond a reasonable doubt. And if you determine that they have done so, you convict. But if they are missing any one single element, it is a not guilty verdict. And you saw the spreadsheet that the state put up, right? The elements are a little different in each of these cases. And some of these elements will take less of your consideration. You will have to look at the evidence, and you will have to, for example, determine is Cup Foods in the city of Minneapolis, is Minneapolis in the county of Hennepin, is Hennepin County in the state of Minnesota? Did this happen on May 25th, 2020? Right? It's going to take less of your consideration, but nevertheless, you have to do that. You have to go through that process. 2 of the elements that I want to focus on during the course of my discussion here today, 2 of these elements are common throughout, or 2 of these issues are common and apply to all 3 counts. And so I want to focus my remarks today on those 2 issues. The first, were Mr. Chauvin's actions an authorized use of force by a peace officer, right? Because in the instructions, it specifically tells you no crime is committed if it was an authorized use of force, period, end of discussion. The second is an element that is and does appear in all three counts. That is the cause of death. What caused Mr. Floyd's death? And we're going to talk about that second. So, let's start with the concept of reasonable force. As the instructions read in their entirety, no crime is committed if a police officer's actions were justified by the police officer's use of reasonable force in the line of duty in effecting a lawful arrest or preventing an escape from custody. The kind and degree of force a police officer may lawfully use in executing his duties is limited by what a reasonable police officer in the same situation would believe to be necessary. Any use of force beyond that is not reasonable. To determine if the actions of the police officer were reasonable, you must look at those facts which a reasonable officer in the same situation would have known at the precise moment the officer acted with force. You must decide whether the officer's actions were objectively reasonable in light of the totality of the facts and circumstances confronting the officer and without regard to the officer's own subjective state of mind, intention, or motivations. The defendant is not guilty of a crime if he used force as authorized by law, and to prove guilt, the state must further prove beyond a reasonable doubt that the defendant's use of force was not authorized by law. So, if you remember from my opening statements and how I talked about reason and common sense, right? The reasonable police officer standard. I want to just briefly add one thing here, is the standard is not what should the officer have done in these circumstances. It's not what could the officer have done differently in these circumstances. The standard is what were the facts that were known to this officer at the precise moment he used force, and considering all of the totality of circumstances and facts known to the officer, what would a reasonable police officer have done? You have heard from numerous experts, police use of force experts, the training department from the Minneapolis Police Department. You've heard from police officers, street police officers, Sergeant Edwards, Sergeant Pluger, right? So you've heard from these people, and they have given you their opinions at various stages as to the reasonableness of the use of force. But one of the things that one of the things that all of these police officers effectively agreed to is that when you look at the question of what would a reasonable police officer do, knowing the facts of the case, there are things that a police officer is entitled to take into consideration above and beyond the facts, right? Their training, the training that they receive, their experience as a police officer, the department's policies on the use of force. And all of these things kind of lead into the question of, most critically, what are the facts that were known to the police officer, the reasonable police officer, at the precise moment the force was used? So you can start at a very high level, right? What were the reasonable police officer's knowledge of the area be? Is this a high crime location? Is it a low crime area? Those are things, those are facts that a police officer would know. What are the specifics of the location of arrest, right? Am I going into a densely populated urban environment, or am I in a kind of a secluded backyard, right? Officer is calculating these pieces of information and assessing the risk, assessing the threats. Officers are entitled to kind of take into consideration things that you and I don't think about. Their tactical advantages, their tactical disadvantages. They can take into consideration the scene security, keeping the scene secure, and security of the scene, right? Those are two different concepts. So kind of, again, focusing back into what facts were known at the precise moment force is used, you can then take into consideration kind of this mid-range level of information. A reasonable officer wants to keep his fellow officers safe. A reasonable police officer takes into consideration the safety of civilians. The reasonable police officer takes into account the safety of the person that they are arresting. They take into account what resources do I have based upon how close am I to a hospital? What's the expected time if I call EMS? Because a reasonable police officer at times, they got to put the person in their squad car sometimes and take them because they're farther away. Calling for help, bringing help in would take longer than it would simply to take the person directly. And then you look at the direct knowledge that a reasonable police officer would have at the precise moment force was used. That includes information that they gather from dispatch, their direct observations of the scene, the subjects, and the current surroundings. They have to take into consideration whether the suspect was under the influence of a controlled substance. They can take into consideration, because again, this is a dynamic and ever-changing, just like life. Things change. It's a dynamic situation. It's fluid.